At independence in 1960, Nigeria inherited the common law legal system from her colonial masters. And that is what we have operated up to today. But that is not to say that the various entities that made up Nigeria at that time did not have their own various legal systems through which they governed themselves. Now, how did these systems collapse into the common law system over the years? How impactful has the legal system been on the Nigerian polity in 60 years? These and many more issues are the issues we shall be looking at in this special edition of The Scale. Welcome to the program. I am Femi Okeowo. You see that in line with the times, we have moved out of the studio to see what the 60th independence anniversary of Nigeria has been like. But what concerns us most on this program is the legal issues that have helped us to survive as a nation. Whether during the First Republic of which we operated the parliamentary system, or the various military interventions, and indeed now with the presidential system of government, the law has remained the anchor on which all our political systems evolved. But how impactful has the law been on Nigeria? How respectful are our political systems of the rule of law on which they must govern? These are the issues we have put before some key personalities, legal personalities, on the scale today. They are not many, but they have the idea of what it was at independence when our law was still evolving, and now what it is, how impactful it is on our system. So join us as we speak to some legal luminaries, if you allow me to call them that, on the development of the law of Nigeria in the last 60 years.
During the amalgamation of northern and southern Nigeria, our colonial masters allowed the common law to operate side by side with the Islamic law and customary law. But unfortunately, they call this Islamic law as part of customary law too. But why Islamic law is not part of customary law is that customary law is largely not written, but Islamic law is written. But they classified it as one. To be fair to them, they allowed us to operate our customary law alongside with their own, according to them, as long as it is not repugnant to natural justice, equity, and good conscience, which is something you cannot really define. That is customary law, good conscience, that is according to the British system of good conscience and so on, which sometimes will not even amount to good conscience. For instance, in under the customary law, even if you see an old man of 90 years getting burnt in an inferno, and you have the ability to save him, you don't save him, you have not committed any sin. Under the customary and Islamic law,
Those are sins.
Those are unforgivable sins. So
Yes.
that one too is subject to
debate
some
entirely.
qualification, which
Yes.
I normally don't agree with.
Okay. Okay. So now, how did the penal and criminal code, how did they then evolve?
You see, the penal code in particular was fashioned on the Sudan penal code. But that is where the interest of the non-Muslims and Muslims were taken into consideration. So the penal code was fashioned particularly based upon the Sudan penal code. The penal code, for instance, comprises of almost everything you think about, even things that are not offenses are made offenses based upon our notions of right and wrong. The same thing with the criminal code in the South, except that with the criminal code was essentially based upon the customary law of the South.
Okay.
In the North, it is an amalgamation of both the Islamic law and our native law and custom.
Okay. Let's move up quickly into after independence. There is this notion that the rule of law was respected in the early days of our nationhood more than now. How true do you think this notion is?
You see, I agree to some extent. The rule of law was obeyed more then because those people who fought for our independence, Sardauna, Awolowo, Azikiwe, and so on, were more united than we are today. And those people had this belief that, look, give us independence, we'll be able to sustain ourselves. And like Azikiwe used to say, he said, look, I used 25 years to fight for independence. I don't care who emerges as the prime minister or president, as long as you give us independence. With that notion, they were able to obey court orders, rule of law, and the rest of them, which is normally so after the 1966, unfortunate 1966 coup, which has brought a lot of misfortune, a lot of moving backwards to Nigeria. That type of nationalistic attitude is no longer in existence. It is not, and that is why the rule of law, rather than moving forward, to me, is substantially in reverse gear. For instance, now some governments may not even obey the judgment of court if it's not palatable. And it's not only the government too. Even with the individuals are not nationalistic enough, because anybody who is nationalistic must obey the rule of law, which is principally based upon court judgments. For example, the recent attempt by NLC and so on to go on strike, there was a court order. They insisted on going on. I say, what is really happening? Until the National Assembly and so on fortunately intervened. You know, one thing we do not know. The moment you say you are not obeying court order, it is just like throwing stone in the market square. The first person it may meet may be your mother-in-law. You say you are not disobeying it today because it's against you. Tomorrow, when you get that order in your own favor, your opponent will not obey it, and then that will be anarchy. Are we ready for anarchy? I don't think we are.
What is your assessment of the level of development of our legal profession and the judiciary in Nigeria? What's your assessment?
You see, I've always said it time without number. I don't have any brother, I don't have any sister on the bench. But let me tell you, without the judiciary, particularly the Supreme Court, Nigeria would have since collapsed. Let me trace the history. Right from the word go, right from the time of the military, the Gowon era, the case of Lakami, when the military came and say they brought decree and so on. the judiciary, the Supreme Court then, it still had the gut, facing the gun, had the gut to say, look, yes, but the military decree has not and cannot supersede fundamental human rights. That was how Adetokunbo Ademola was removed. Despite that, our judiciary continues, like the case of Atiku Abubakar, I told you. Yeah. In fact, when judgment was to come up, Obasanjo now declared that day public holiday. but they gave the judgment the following day. If you look at these things, without the judiciary, honestly, Nigeria would not have been the Nigeria as we see it today. The examples are too many. For instance, the issue of our politicians today. Our politicians have never learned, and I don't know, maybe after the demise of old people like us, are not likely to learn. They continue to commit the same sin, the same thing, killing people for election, maiming people, sponsoring thugs, and so on. Like in some states, which I won't mention now. But for how long are we, if not because of the judiciary?
That's the issue.
Nigeria would have since exploded.
Do you think the judiciary still has the courage, which you cited as part of their identity?
The judiciary, I'm telling you, quote me anywhere, even in my grave, quote me. The judiciary, among the three arms of the government, the judiciary is comparatively the best up to today. Look, particularly the Supreme Court, and I've always said so. I've no relation on the bench, but at my age, if I don't tell the truth now, when is it in my grave? Without the judiciary, without the courageous nature of the judiciary, particularly our Supreme Court, Nigeria would have since collapsed.
There is the professional ethics that lawyers must defend.
No, yes, you must defend, but you should tell him the truth. Look, let me tell you. A particular case I won't mention. A governor said I should represent him this for a review. I said, Your Excellency, Supreme Court cannot review itself. You won't win. He said, Amumu. Now, when they went and lost, the same man called me, thanked me, and gave me 5 million free for doing nothing. You see, but I want lawyers to know this. It's not the clients who feed you, it's only God who fend for you. Only God and God alone. If you have this belief that only God and God alone fends for you, not the clients, in fact, you will make more clients. Tell them the truth. They will go away, abuse you, but when they go away and lose, they will come back to you.
The British, when they conquered the colony of Lagos, as it were, in 1861, with the ceding of Lagos, of course, started to make their inroads into other parts of the country, starting from Lagos and then ending up eventually in the north. Of course, they brought their legal system, but Nigerians were not without their own legal system before they came. In the north, there was the Islamic law. In most of the south, there was the native law and custom. What did they and the British, in fairness to them, they appreciated that there's no way they could abolish these other systems. Okay. So they found places for them. What they did then was to put what we usually call the repugnancy test in their own laws, that any native law that is against good conscience and this cannot stand with their own common law. And then, of course, with the common law coming here, the court system started. So at independence, the court system we had was the Federal Supreme Court as the highest within the country. Then you have these various high courts of the regions. As at independence, up to 1963, the final court for Nigeria was the Privy Council in England. But upon attainment of Republican status in 1963, the Supreme Court of Nigeria came into being. So the old Federal Supreme Court became Supreme Court of Nigeria, and all appeals started to end in Nigeria. Now, in the colonial period, pre-independence, like I said, the British found a way to accommodate the existing legal order they found in Nigeria, incorporating it into their own. What they just did about Islamic law was that they took away most of the criminal jurisdictions of those courts and left all the personal Islamic law matters with them. One significant thing they also did was to ensure that those our local courts, customary courts, native courts, that there were appeals from those courts to their own courts. All they just did was to ensure that, for Islamic law, for example, they will now say somebody who is learned in Islamic law must be impaneled in the appeal. Yeah. The same thing for customary law. And that's what we carried on.
And which is it's still up
to today. And of course, the only major thing that affected the court system was the 1999 Constitution, which now came and made the Supreme Court the apex court, the Court of Appeal, which is a federal court, as the appellate court, then the various high courts. As at 1979, when we adopted the American system, those were the courts we had: the state high courts, the customary court of appeals in most of the southern states, and Sharia court of appeal in all the northern states virtually. And then at the federal, what used to be the Federal Revenue Court now became the Federal High Court. Subsequently, after 1999, we now have National Industrial Court. As at that 79, we also had, eventually we now have the Federal High Court, Federal FCT, Federal Capital Territory High Court.
There is this thinking that at independence and shortly thereafter, in Nigeria generally, the rule of law was more effective than it is now. Where did that thinking come from, and does it have any basis?
Of course it does, because look, we inherited something from some people. And because it was so soon after independence, most of the founding fathers themselves were trained in the observance of rule of law. Rule of law started to have problems in our country with the intervention of the military in 1966. Because military does not understand rule of law, they only understand the rule of force. And that's why it was possible for them to suspend the operations of the Constitution and made their own peculiar type of law, which they called decrees, to be superior to the unsuspended portions of the Constitution. So it was military rule actually that formed the bedrock of the erosion of the rule of law in our country. And you have to appreciate that most things are historical. Because we had such a long period of military rule, our psyche as a people became militarized. So that was why we expected that things should happen like God created the heart and the heaven. Let there be water, there must be water.
Is that what still affects our polity up till now?
Yes, it's going to take some time for us to get out of that, because it has created a mindset for us. And I'll give you an example. In the First Republic, I was old enough to know how parties were being run. Yes. In those days, those who belong to the political parties, once you register as a party member, you are issued with a card that looks like a daily contribution card. So whenever you attended party meetings, whatever time it was in your ward, you must contribute to that's what kept your membership alive, contribution to the party. And it was such monies that were used to run the parties and run elections. But those things changed from 1979. Then, in fact, it became more pronounced in 1999. You now have individuals owning the parties as their own private entities. So, party men, usually in Nigeria today, party men now expect parties to pay them rather than the other way around. And that's where part of the problem we have with the brand of democracy we practice.
What is your assessment of the level of development of the legal profession and the judiciary since independence?
It's been quite awesome, tremendous. At independence, the number of lawyers we had were so few. Today, we're talking in some 100, over almost 200,000 lawyers.
Members?
Yes, almost 200,000 lawyers in the country, both at the bench and the bar. Yes. So there has been tremendous progress in terms of human capital development for law in our country. And of course, because lawyers now are many, the awareness that you can consult lawyers because they are easily available has also heightened people's consciousness about their legal rights.
How about the judiciary?
The same thing with the judiciary has grown. At independence, there was no court of appeal at all. We only had the regional high courts. So today, not only do we have the Supreme Court, we have the Court of Appeal. Each state has its own high court. Many of the states have customary Court of Appeal, Sharia Court of Appeal, and then you have the Federal High Court, you have the FCT High Court, you have the National Industrial Court, and of course, we have the Code of Conduct Tribunal, which technically is not a court as such, but at least functions as a tribunal that tries public officials for non-compliance or infractions of the Code of Conduct. So the judiciary has come of age. Today, I'm not aware of anybody, either in the Court of Appeal or Supreme Court, who was not a Nigerian trained lawyer. I'm not aware of anybody, either in the Supreme Court or the Court of Appeal today, not talk of the High Court, who was not trained as a lawyer in our country. Whereas at independence, all the judges of that time were trained outside of Nigeria. Because if you remember, the law school came only in 1962. There are still courageous judges in our country, as there were at that time. And I can tell you that most of our judges are men of courage. Sometimes, expectation of people about law and judgment is different from the reality. Judgments and cases are based on facts and law. So the citizens, because they are not schooled in the arts of the legal issues, their own expectation may be different from the outcome of some cases. That is to be expected. But that does not mean the judges don't have the courage. No.
As we move into the 7th decade of Nigeria's independence, what are your expectations as it regards the law, the profession, and Nigeria's development?
On the law, I expect us to be more robust as we start our going to the 70th year of our country. I expect that our law will be developing to meet the expectations and serve the expectations of the society. Many of our laws are overdue for reform. I think these are things that should be attended to from time to time by the legislature and the executive.
By human lifespan standards, 60 years is quite a lot, edging towards old age. But in nation building, 60 years can just be beginning. And so we must continue to work towards building our nation. Of course, I hope we are not saying that we have lost 60 years in the past. And even if we have, we still have the future ahead of us. We're edging into the 7th decade, and we must all continue to work to develop our country. Now, the law forms the basis of any sound development. We cannot afford to disrespect the law and the rule of law. And so we would continue to look into this issue in the coming weeks. It is not an issue that can be discussed only once and for all. it is an issue that Nigerians should continue to toil on and ensure that we get a full grasp of what the rule of law is and how it can impact on national development. Thank you for being part of The Scale today. It will continue about this time next week. We'll see you again. I am Femi Okeowo from the Eagle Square in Abuja.